I'll summarize as follows since we're on the point.
The public in this case is represented by the Board of County Commissioners, duly elected by the public, who have appointed and established the Hardy IDA. They have expended public money in these proceedings trying to bring Your Honor the appropriate facts and law to resolve the issues initially raised by Mr. Coleman. We've raised 4 particular questions at the tail of our complaint. Those questions are, number 1, whether the requested records are public records. Number 2, who is the custodian of those records. Number 3, whether the Hardy IDA is obligated to demand the requested records from CLA and become the custodian thereof. And question 4, whether the requested records are confidential and exempt from production to the public under Section 288.075, and if so, who should redact confidential information from those records. CareSync is best suited to identify its confidential information and trade secrets, and who should pay the cost of that redaction. Those are the 4 questions raised. The records requested by Mr. Coleman, which have not already been produced, and many have, were not records made or received by the Hardy IDA. That's a very simple analysis. It's straight from the statute, and it is clear on the record in the affidavits of Mr. Lambert and Christy Shireman. So test 1 immediately is resolved in favor of the IDA and makes your answer undisputed and easy to render on question. The records requested by Mr. Coleman, which have not already been produced, and many have, were not records made or received by the Hardy IDA. That's a very simple analysis. It's straight from the statute, and it is clear on the record in the affidavits of Mr. Lambert and Christy Shireman. So test 1 immediately is resolved in favor of the IDA and makes your answer undisputed and easy to render on question 1. Whether the records are not public because CLA is not an agency according to 119. Whether they became public records because of the position of CLA. That's an analysis in the Schwab case. It's cited in the memorandum. And 3, whether the activity was conducted on public property. The affidavit of Mr. Lambert says, no, it's not. It was conducted by CLA and their offices. Number 5, whether the private entity, that would be CLA, is performing a governmental function which the public agency otherwise would perform. In that instance, not only no, but it could not. The very nature of an independent audit is its independence from that of the agency. 3, whether the activity was conducted on public property. The affidavit of Mr. Lambert says, no, it's not. It was conducted by CLA and their offices. Number 5, whether the private entity, that would be CLA, is performing a governmental function which the public agency otherwise would perform. In that instance, not only no, but it could not. The very nature of an independent audit is its independence from that of the agency. So again, the answer is no. Number 6, if you will, of Ms. Shireling, the affidavit dated September 29, it is of record. Actually, I believe the affidavit of Mr. Lambert is more telling. Ms. Shireling will support that. He ticks down those issues. That Schwab is making an independent review. It was not on publicly owned property. They didn't do it in his office. The IDA has no financial interest in CLA, does not fund CLA, and CLA functions for its own benefit, not those of Mr. Lambert, and that he has no control over CLA. So the record is clear at this point. Under the Schwab analysis, CLA was not conducting a public function. Schwab makes clear that an agency can hire a private entity to perform services for that agency and not be swept into the public function cubicle, if you will. And this is clearly one of those cases. The record is very clear, the facts are before you. Who is the custodian of the requested records? Quite frankly, the Hardy IDA does not have the records. All we can do, and I believe everyone in the room is aware, the records reside with CLA. That's never been really contested. Mr. Coleman takes that position. So those records are in the possession of CLA, and because CLA is not a public agency under Schwab, they are not public records. Question. Whether our Hardy IDA is obligated to demand the records from CLA and become the custodian. There's no case law in Florida that requires one entity, one agency, to require those records be placed with it and become the records custodian. Question 4 is the meat of the issue. Whether the records requested are confidential and exempt from production. Now, quite frankly, Hardy IDA doesn't have the records. We don't have the ability to delve into those records and make a representation to Your Honor what is and is not exempt under 288, and that is in between 119 and 288. That someone has to actually make the analysis, review every page, and in this case, we believe it's quite a number of pages, and determine whether they're public or whether an exemption would apply. We believe first that they're not public. They're not residing with a public agency. They're not created under 1, 2, and 3, the first 3 questions. But we would like Your Honor, and we've asked in this declaratory action that Your Honor give us a protocol, tell us how these should be handled. We've tried to conduct this lawsuit as civilly as absolutely possible. I appreciate that Mr. Coleman is acting as a member of the public, but he's done the equivalent of shouting fire in a crowded theater from time to time and making accusations that are unfounded. And for those reasons, we would like Your Honor to adopt the protocol. The protocol was proposed and filed some time ago at your request. There's a memorandum of record. The last part of that memorandum gives you a suggested protocol to consider. It's based on the case law. The cases are cited in that protocol. One of the issues is, and this case begs the question, when a records request is made for a huge number of documents, and it is going to require lawyers or people from CareSync to sit and evaluate every one of those records to say, are our secrets in that? Because they're clearly exempt from production if so. Someone's got to pay that cost. And the man wanting the records is the one that the law says has to pay that expense. So we would ask Your Honor to consider and adopt that protocol under question 4. There's been, I know, no basis to dispute that protocol. I also would respectfully point out, I believe your opinion should say, under the law today, this is the protocol. We don't know what the law, how it will evolve in the future. But that will give a roadmap for this agency to deal with Mr. Coleman's continued request for information to determine properly whether it is public or not. This agency has a good reputation and a good track record that Mr. Coleman has not been able to impeach for giving him and responding promptly to his public records request. In this case, Your Honor, Mr. Coleman wants to say, look at 119 and don't even look at Chapter 288. Chapter 288 was adopted by the same legislature that adopted the laws of Florida on 119. And 288 says that a certain number of these records, when the public is going to assist private entities for the purposes of economic development, those private entities are not required to disclose their trade secrets. The people of Hardy County, through their elected representatives, have made a policy decision that that would be done in this county. Mr. Coleman may disagree with that policy decision, but his disagreement should be lodged at the ballot box, not as an attack on the Hardy IDA. and that's what's been happening. So we would ask Your Honor to answer these questions set out forthwith, without further delay. I appreciate your 20-day point that he's given an opportunity to argue further, as I understand the court's ruling. But we would ask you to enter a summary judgment, basically following the motion we have filed. Thank you for consideration this morning, Your Honor.
Mr. Harris? Thank you, sir. Mr. Duval?